Good afternoon, everyone who have joined this webinar. The today's topic, which is assigned to me, is related to filing of appeal. And friend, this is the high time where we are involved in filing of the appeals under the GST regime, and GST being the new law. This is, the first time 2017-18 year, the first year of the implementation of the GST has become time barred so far as the adjudication process is concerned under Section 73 of the CGST Act on 31st of December 2023. And many states have issued bulk notices under Section 73 for the year 17-18 and after that 18-19 also, and whereby a large number in cases either they have become ex parte or the demand has been raised by the adjudicating authority relating to the year 2017 and 18. And appeal is otherwise also very important. In many cases, we had the earlier orders also, and we are handling the 129, Section 129 cases also, detention of goods during transit. In all these cases, we need to file the appeal, and appeal is an important tool to litigate or mitigate the liability which has been arisen due to the adjudication order passed. Now, let us understand the purpose of this seminar is twofold. One, mainly, what are the provisions relating to the appeal which are there under the GST law? How do we comply with those provisions? And secondly, how to handle the appeal effectively, and how do we get out of the appeal? What types of facts of appeal or grounds of appeal we should have, and or other related issues we need to address and handle related to the appeal we are going to discuss here. First of all, if you see, the earlier legacy laws also was having the provision for filing of the appeal. And under the state VAT acts, like in Delhi DVAT Act and other states, we had the provision for filing of the appeal. And service tax also having in Section 85 of the Chapter 5 of the Finance Act of 1994, the provision relating to the filing of appeal in 2 months' time is given under the service tax law. And under the GST, we had a provision under Section 107, which talks about the appeal to appellate authority. Friends, here we are mainly talking about the first appeal to the appellate authority, because second appeal lies to the appellate tribunal, which is under constitution and has not yet been constituted, and it may take some time to formally function the GST appellate tribunal. In this first appeal, when we discuss that what the appeal specific is, what is the remedy available to the SSE or the supplier relating to an order, so we can understand there are 2-3 terms which is commonly used. One is the appeal. So what the appeal meaning is itself? The appeal is going to the higher authority, and challenging the order, the decision passed by the adjudicating authority or the lower authority. It may be on the law, it may be on the facts, and we pray to the higher authority to correct the order pass, or to quash the order, or to delete the demand, or whatever relief we require from the higher authorities. This is the general mechanism, and in taxation laws, the specific appeal machinery, appeal mechanism is given, and following with the appeal procedure, we file the appeal. And this is the specific remedy given by the special statutes. And general remedy, like constitutional remedies, which is available to the High Court under Article 226 and to the Supreme Court. The writ jurisdiction of high courts is a constitutional remedy that is called the extraordinary jurisdiction, where even if the appeal remedy is available, but in certain circumstances, the high court can admit the writ petition, against an order passed or against the show cause notices and exercise the extraordinary jurisdiction. So we will discuss about that also, but this is the appeal, which is the provision it is specifically given under the statute, like under the CGST Act 107 has been specifically mentioned that any person who is can file the appeal against a decision or the order. Second term which is used is review. So what is the review in contrast with the appeal, and when can we approach, when can there be a review? Basically, review is done by the same authority who has passed the order, and there can be review based on the facts which was already there. There can be review new evidence or fact which is coming into the notice, and based on that, the authority who has passed the order, the quasi-judicial authority, can review the order if there is a provision to review. But under the GST law, we do not find any provision which allow the adjudicating authority or the proper officer to review the orders passed by itself. So once the order is passed, now the ball goes out of the court of the proper officer or the adjudication officer. We need to have the remedy, and that remedy may be available to the higher forum or any other remedy, but certainly the remedy do not lie with the same officer who has passed the order, so far as the review is concerned. And another, terminology which we use is the revision. Basically, revision is a supervisory function, or function of the higher authorities to supervise the orders being passed by the subordinate authorities, whether they are as per the provisions of the law or whether they are legally passed the order. And a revision can be made by the superior authorities and to protect the interest of the revenue, or in some cases, if the law allows, in the interest of the supplier or SSE also. So revisionary power is available to the higher authorities, like the appeal, but the difference between the appeal in revision is quite, different provisions. Appeal is something where we are challenging the order passed by the lower authority, and that have a hierarchy, and appeal can go up to Supreme Court. But the revision is a limited power. In that case, the revision is done by the higher authority or the order passed by the subordinate authority, but it can only have, single chance for revision. And, in revision, so far as the GST is concerned, Section 108 is the revision by revisionary authority, and that is only possible when it is in the interest of the revenue. So that point we need to take care that in GST, there is no scope for going against the order for revision in favor of the supplier or doing some benefit of the supplier. So we have the remedy. That remedy is only filing the appeal so far as the litigation is concerned. But another extraordinary jurisdiction, which just I told you about, the going to the High Court under the Writ in Article 226 of the Constitution. That is the separate issue, and that we will discuss here also. How do we effectively handle the appeal? In what circumstances we can choose opt to go to the High Court rather than filing the normal appeal before the appellate authority. Now, friends, the question comes about the rectification. Another term which is used is the rectification. Rectification is basically quite different from all these terms which we have just discussed. Rectification is neither appeal nor review nor revision. It is something, a mistake, the rectifying a mistake. And mistake has a quality that if two parties are involved, both the parties will say, yes, it's a mistake. So that is the quality of mistake, that it is a mistake or error which is apparent from the records. And generally, when the mistake is there, But practically it happens that we go for the rectification and department says there is no mistake apparent from the record, and hence the application for rectification is rejected. And we see under the provisions of direct taxes also, the rectification applications are being moved, and in many cases these applications are rejected by the uh, tax authorities. So we need to understand there is section 161 under the CGST Act, which allow the officer, we will discuss, to rectify the error which is apparent from the record, and a time limit has been given. Now, if you see the provisions relating to the appeals and revisions under the CGST Act, that is section 107 to 121 is dealing with these provisions, and rule 108 to 116. And if you see the hierarchy of the appeals available, the first appeal goes to the appellate authority, that is under section 107. Then the revision authority is 108. Then second appeal to the appellate tribunal goes, and then appeal to the High Court, and then appeal to the Supreme Court. So this is the all hierarchy given for the appellate proceeding under the CGST Act. But you see, so far as the matter relating to facts are concerned, mainly nowadays for the year 2017 and 18, the major litigation is under section 73, where the notices has been sent due to the mismatches. And that mismatches is mainly the invoice level data generated in GSTR 2A or at that time, and the reconciliation with GSTR 3B. And in many cases, the related to the block credits or the reversal or the cancelled supplier, there is a dispute which is going on. If you have availed the ITC on the invoice, which has been issued by the supplier, which has been cancelled later on, retrospectively, when you bought the goods or when you availed the services, that supplier was registered, but now at this current time he is cancelled, and the cancellation has been made with the retrospective effect and impacting the period for which the invoices has been raised to you also. So that is the cases related to the facts of the matter, and the tribunal being the final fact-finding authority, all the issues, disputes related to the facts rest after the decision of the appellate tribunal. And the issue, if there is a legal issue, then the question of law is being framed, and the High Court can accept the appeal on the question of law and substantial question of law, and accordingly the appeal to Supreme Court. This is the section 161 regarding the rectification, which I was just referring, because this is a separate altogether the mechanism which is there in other provisions of the GST law. It is not within the chapter of the appeal and revision. It is after that, and it applies to each and every type of order or any type of notice or certificate or whatsoever. If there is a error and that error is apparent on the face of the record, then that can be rectified, and application for rectification can be made by the supplier, or it can be suo motu also. It can, whenever it comes to the notice of the officer, and this is to be done by the same officer who have passed the order. This is not the higher authority. This is the same officer, and the 3 months time has been given to apply for the rectification. And further, where 6 months period has been the final time outer limit has been prescribed, that no such rectification shall be done after a period of 6 months uh, from the date of issue of such decision order. Uh, that is the and further, this 6 month period is not applicable when there is a arithmetical or clerical error. Then this period itself is not applicable. For example, if there is a totaling mistake in any order, so that can be rectified at any moment of time. Now the important question comes that in these circumstances and the order being passed by the department, How can this tool of rectification be used so far as Section 73 adjudication order has been passed? If you see, if there is an error, means mistake, and which is apparent on the face of the record. For example, if the show cause notice was issued and in the show cause notice, 3 points were raised so far as the demand is concerned. Out of the three, you deposited the tax in against the two issues, and only one issue remained pending. But when the order came, you deposited the tax also, you attached the copy also along with the reply. But when the order came, the whole of the demand has been raised in the order. When you have agreed on some 2 points and you have deposited the tax amount and the copies of the along with applicable interest and whatsoever, and the copies are being enclosed along with your reply, then it's an error which has been committed at the time of the passing of the order by not considering the tax deposited by the supplier or the taxpayer, and that we should approach under Section 161 for rectification of the order. And once the order is rectified, then it will be easier for you to file the appeal against that rectified order, because otherwise you need to file the appeal against the whole of the amount, although uh, part of the amount is admitted, but that admitted amount will not be adjusted in your APL form, because you need to pay the tax against that admitted amount which you have already paid. So at the time of the passing order, the proper officer must have considered the appropriating the amount which you have already deposited and raising the demand against the balance amount, so that to make the system easier. So this is, regarding the rectification. Now one issue comes in our minds, and that issue is there, that the Honorable High Court has the extraordinary jurisdiction by way of writ under Article 226. The question comes when we should uh, go for the writ jurisdiction, or when we should file the appeal under Section 107, that is the first appeal. And generally, if we see, the one basic concept is there. When the remedy is available under the statute, when the statutory remedy is available, there should not be any writ under Article 226. When you have alternate remedy, you can file the appeal against the order. You should file the appeal against the order. But there are certain circumstances where, by rather than filing the appeal under the statutory remedy available, in one of the recent cases, the Honorable Supreme Court in Godrej Sarali Limited, and this is 2023 case 2 TMI 64. It was discussed in detail that what are the cases where the writ can be filed before the Honorable High Courts under Article 226. And some of the major points have been given here, which I would like to give attention. And further, this order of Godrej Sarali Limited, in this order, one another landmark judgment of Honorable Supreme Court in case of Whirlpool was also discussed, and that we will take. And the Honorable Court has opined that Article 226 does not in terms impose any limitation or restraint on the exercise of the powers to issue writs. So there is no restriction on the high courts to exercise the jurisdiction under Article 226. That's why I told, even if the alternate remedy is available, to file the appeal under the statutory, remedy available under the specific act. But if you see, that is not the sole criteria. While it is true that exercise of writ power despite available of a remedy under the very statute which has been invoked and has given rise to the action impugned in the writ petition ought not to be made in a routine manner. Yet, the mere fact that the petitioner before the High Court in a given case has not pursued the alternate remedy available to him it cannot mechanically be construed as a ground for its dismissal. So it cannot be said whenever there is a alternate remedies available, the writ will be dismissed. This is not like that. There are certain instances, there are certain situations where the High Court will exercise the jurisdiction under Article 226. Even the alternate remedy is available, and in those cases, the writs are being admitted. And we will discuss those cases also. And further said that High Courts have a discretion whether to entertain a writ petition or not. So that is the discretion of the High Court, and very wide power has been given under the extraordinary jurisdiction to the Honorable High Court. And at the same time, it must be remembered that mere availability of an alternate remedy of appeal or revision, which the party invoking the jurisdiction of the High Court under Article 226 has not pursued, will not ask the jurisdiction of the High Court and render a writ petition not maintainable. So that has been clarified and clearly said by the Honorable Supreme Court. Further, they referred the judgment of Whirlpool Corporation also, and that is a 1998 judgment of Honorable Supreme Court itself, and where they have carved out the exceptions on the existence of whereof a writ court would be justified in entertaining a writ petition despite of party approaching it not having availed the alternate remedy provided by the statute. So this is summarized in these fine points. The number one, where the writ petition seeks enforcement of any fundamental right. When there is a right to do business, there is right to equality. If there is a violation of any of the fundamental right and you are wanting to enforce those fundamental right by way of writ, then even if the alternate remedy is available, the High Court can exercise the jurisdiction and pass the appropriate orders. Further, where there is a violation of principle of natural justice, in that case also, the High Court can be approached. And a principle of natural justice is that if any order has been passed without allowing the opportunity of being heard, no personal hearing was allowed, order passed, that is in violation to the principle of natural justice. And in that case, the court can enter, and in such a case, the court can quash the order, and further it can say that matter is remanded back for further, opportunity to be allowed. Only then the order can be passed. Further, if the order passed is a non-speaking order, where the reasons for not accepting the reply by the supplier or SSE has been considered, and simply the demand has been fastened without any reason or justification given, so that is also a violation of principle of natural justice. In these cases, the directly High Court can intervene and order the appropriate order. Where the order or proceedings are wholly without jurisdiction, there may be many cases where the order has been passed even without jurisdiction. Without jurisdiction means the jurisdiction may be due to limitation, lack of jurisdiction, and lack of jurisdiction may be due to the over exercising the power which are not given under the statute. So if over exercisation of power or exercisation of power after the limitation period, this is all without jurisdiction. But it says are wholly without jurisdiction. So grossly we have to see if any order has been passed grossly without jurisdiction, the Honorable High Court can intervene and accept the writ petition. And where the virus of an act is challenged, in many cases the notifications are challenged, like a provision of the act are challenged, like in case of inverted duty structure the provision was challenged. In case of this the extension of limitation under section 168A of the CGST Act force measure for 73 cases, that has already been challenged in many of the high courts, have entertained the writs, and the proceedings are going on, and interim relief in some of the cases has been provided. So if any of the virus is challenged, when it is extraordinary power has been, beyond the competence has been issued or has been made, then also the writ jurisdiction lies. So with this background, I wanted to make a sensitization of the issue. The issue is that there may be certain cases where rather than going in the appeal, you would like to go to the writ jurisdiction, and there none of the procedure of the CGST Act applies. It is only the High Court procedure. It is only the Constitution applies, and there the relief, any kind of relief, the court can pass on. Now, uh, the issue comes: what is appealable under GST? So what is appealable? If you see the section 107, which is the first appellate authority, and the subsection 1, which is very important, it says that any person aggrieved by any decision or order passed under this act or state goods and services tax act or union territory goods and services tax act by an adjudicating authority may appeal to such appellate authority as may be prescribed within 3 months from the date on which the said decision or order is communicated to such person. This is, very important, subsection 1. So what is appealable, how it is appealable, what is not appealable, what is the timeline for appeal, this all has been prescribed, that all has been given under the law, either in act or rules. And if you see the section, read with relevant rule, you will find. But very importantly, any person can file the appeal. So it is not written that only the registered person can file the appeal. If you see, the word uses any person. The person may not be registered, but certainly there must be any decision or order against that. And that has been passed under the Act. Read with CGST and SGST are perimetria. So if any person can file, there are provisions when the assessment can be made on the unregistered person also. And they may be allowed the temporary registration, and that can be called for the time being that they are temporarily registered, or for ease of technology, there can be some sort of registration. But the appeal provision says that any person can file the appeal. And from what aggrieved? It is the decision or order that is appealable. Very important. You must find out the order or decision, and that is passed by the adjudicating authority, that is appealable. So if you see, the two terms are used jointly, a decision or order. So what types of orders are appealable, decisions are appealable? There is a, what difference is? These are used as synonyms. But if you see the order, basically this is the order in a quasi-judicial function by the authority, like the adjudicating authority. They uh, they generally uh, they generally being passed uh, to fasten the demand or allow the refund or like these. And decision sometimes can be administrative also. And many administrative decisions are being taken, like blocking of input tax credit, or not allowing registration or cancellation, or these types of decisions. So if you see, both types of decision and order are covered under Section 107, and that is, very important to see. And that same term is being used under the Customs Act also, and we will see some of the cases where these terms has been defined. And by an adjudicating authority, it is also very important because we need to see who are the adjudicating authority altogether. And then adjudicating authority can only decide, can order passed by the adjudicating authority can only be appealed. And 3 months time has been given from the date on which the said decision or order is communicated to such person. The date of communication is also very important. We need to see what is the date of communication, and from there, 3 months. It is not 90 days or 60 days or 120 days. It is not a matter of days. Month to be calculated based on the month. Days calculation method is different. Months calculation method is different. If suppose any order is passed today, say 22nd of the February, then 3 months will end on March, April, and May, meaning thereby by 21st of May, the appeal can be filed within 3 months. Now, further going, what types of decision or orders are there? For example, we have the adjudication order under section 73, which I just told you. Nowadays, the 1 year has become time barred. Another year is going to time barred on 30th of April 2024, 1819. That is the extended time as per the notification issued. Then the another year 1920 will also be getting time barred this year. So likewise, uh, order adjudication order under 74. 74 are the cases where fraud, willful misstatement, suppression of facts with intent to evade the tax. These types of cases are there. And best judgment assessment or non-filers of return under section 62, these are the cases. One of the question is being asked, can appeal be filed against deficiency memo issued under RFD 03? Deficiency memo for refund, this is RFD 03, is the refund related to refund application. Deficiency memo is not any, kind of decision or order where you can go for appeal. If something has been asked or some rectification has been asked or some more information has been asked. So that is not a decision. Decision is when the refund is rejected. That is a decision. Then you can file appeal. When any action has been taken against you, like blocking of ITC, certainly you can go for appeal. And any other decision which can impact your business, cancellation of application for registration, you can file an appeal. We are coming to that. And then, if you see, uh, some more examples, the best judgment assessment, unregistered person 63. Then summary assessment is there under section 64. Then provisional assessment is there under section 60. Then we have the 129 order, that is the detention of goods during the transit. Then application for registration, cancellation or suspension of registration under section 29. Then rejection of application for revocation of cancellation of registration. If you have filed for an application for revocation and that has been rejected, then against that you can go for appeal. Technically speaking, these registration proceedings are all under the GST law, is administrative proceedings, and this decision, all decision taken regarding this is covered for filing of the uh, uh, appeal. And if you see, uh, there is one, very interesting judgment from Honorable Bombay High Court is DV Projects Limited. This is 11th of February 2022. It is related to GST only. And only the para 20, which is relevant, I am reading. Reading the provision, we can see that the appeal under section 107, subsection 1, can be filed against a decision or order passed under Central GST Act or State GST Act or UT GST Act by an adjudicating authority. It is also clear that this provision does not include any decision or order passed under the rules framed under the Central Act or any other rules. In this case, the respondent maintained that the impugned order or action has been passed and taken under Rule 86A. Therefore, we find no appeal remedy could have been available to the petitioner under this provision. So this is one kind of case there, but it's a Honorable High Court case which is there. On the other side, we have the legacy judgment available in case of Kantilal Somhan Shah, and that is 1982 under the Customs Act. that is High Court of Calcutta. And the section 107 is similar to the 128 of the Customs Act. And it has said that any decision or order as in section so are of wide amplitude and include all orders or decision passed under the said act. Now the question comes, can we say passed under the said act is strictly under the act only, not the rules which has been part of the act, not under the notifications which are the part of the act or rules? So that is a big question to my mind. The appeal lies against the order under rules and notification also that become part of the act only because it's a broader term. It's not a narrower term. But anyway, the judgments are there. And the Honorable Court further said the authorities uh, deciding the appeal as indicated hereafter function as quasi-judicial authorities in the matter of disposing the appeal. And it is also true that these section a complete machinery for obtaining appropriate and necessary reliefs. The availability of the appropriate remedy as indicated hereafter under Article 26 of Constitution of India would be available appropriate cases and under special circumstances. So that is there we have already discussed what are those special circumstances where the appeal will be available. And in one of the cases, Hindustan Steel Cement, this is Kerala High Court, July 2022, it has been that even the proceedings under Section 129, those are also eligible for appeal under 107, and the order passed under section 129 are appealable order. And earlier there was some doubt that whether this order can be appealed because once the amount is paid, the goods is released, and the where is the question of filing appeal? But the Honorable Court said that this is a matter of appeal only. Now, if you see the definition of adjudicating officer, that is very, important because the order of passed by adjudicating authority can be appealed against first appeal. And what is not included in the adjudicating authority is very important. The Central Board of Indirect Taxes, Revisional Authority, Authority for Advance Ruling, Authority for Appellate Authority for Advance Ruling, National Appellate Authority. That National Appellate Authority provisions have not been notified yet, and that is only by way of amendment in 2019, but not notified. Appellate authority, appellate tribunal, and authority referred to in subsection 2 of 171. Now, once there is a order passed by the revisional authority, there is no appeal, first appeal possible because the revisional authorities are higher than the appellate authority. And in case of revision, the appeal goes directly to the tribunal. And like these all authorities, it is already written, you cannot file an appeal against advance ruling. If there is a mechanism available, appellate authority, that's it. After that, if you have any grievance, you can approach to the Honorable High Court under the writ jurisdiction only. So this is important to understand that what types of orders are appealable. Then we have one section 121 where the non-appealable orders has been mentioned. And non-appealable orders are like when there is a transfer of proceeding from one officer to another officer. There may be a change of jurisdiction also. Then these orders are not appealable. One of the question which is coming here is relating to the Uttarakhand High Court judgment in with Vinod Kumar versus Commissioner with respect to delegation of authority. Now these issues are cropping up because GST law being the new law, uh, the appointment of authority per se, the notification relating to the proper officer, the constitution of the appellate authority, constitution of the revisional authority, and especially in the states have some anomalies and lacking of some notification available. And even, relating to the passing of the appeal order, some challenges are being done. So let's see how the time these types of anomalies are rectified by the government. And an order pertaining to seizure retention of books when there is a search under section 67 and there is an order to seize the books or the ledger that cannot be appealed. Order for sanctioning prosecution under section 132 that is not appealable. Order passed under Section 80 for payment in installments, if that has been rejected or allowed partially, that is not appealable. So these are patently non-appealable orders. There is no appeal against this order under any of the appellate forum, neither first appeal, nor second appeal, nor any other appeal. Only if you challenge, then as per the discussion we had, you can approach to High Court. And who can file appeal? Appeal, I have already told you, the any aggrieved person can file the appeal, but very interestingly, the department can also file appeal. The commissioner may on his own motion or upon request from the commissioner of state or UT tax. So that is also very important, and the time limit allowed to the commissioner to file appeal is 6 months. It is available to the supplier. The limitation is 3 months, but time limit available to the department is 6 months. And whenever commissioner, either his own motion or upon the request, will call for the records and examine the proceeding, and if it is he thinks that there is a challenge relating to the legality or propriety of the order, then he can direct any officer subordinate to him, and he will file a application to the appellate authority, and that will be considered as appeal by the department. So this is another beauty of the GST law. In generally in the VAT law, we were not having these types of appeals. And if you further the question arises, where do you file the appeal? The important point is, where do you file the appeal? The appeal can be filed to the officer appointed under the CGST Act, if it is order passed by the CGST Act, and if the order is passed by the Delhi GST or any other GST law, all over India state GST law, then shall be lie to the Delhi GST authorities, not with the central. It means the same hierarchy is to be used. If the decision is passed by the CGST for higher authority will appellate authority, the appeal will be filed. Otherwise, to the state. And one section is bar on civil jurisdiction, that is there under section 162. It is there normally in tax laws that the civil courts are barred from taking any decision. So you cannot go to file the appeal before the civil courts, except the High Court and Supreme Court, which has been there in the appeal mechanism, and except the writ jurisdiction, that is not altogether for discussion. Now, there is one interesting section 160 also. And 160 says that assessment proceeding, etc., not to be invalid on certain grounds. So generally we take the technical grounds, but this section says that if there is any order or assessment or review, revision, whatever, and it shall not be invalid or deemed to be invalid merely by reason of any mistake, defect, or omission. And when it is in substance and effect in conformity with the according to intent of purpose of the act or the law. So when it is in conformity and with according to the intents and purpose of the law, it will not be treated as invalid, and those proceedings will be there. So this section 160 helps in many times, and this 160 is followed by the departmental officer. And now coming to the procedural part. Now, what are the major documents in filing of the first appeal? How you will handle? The first is the APL-01 form. That is the first appeal. This is available online on the portal, and part of the form is there by way of an annexer, and that annexer is downloadable in Word format, and PDF version of that is to be attached with the APL-01. And then the facts of the case, it is there, although it is part of the annexer, but we generally separately annex the facts of the case and the grounds of the appeal, and relied upon documents, evidences, whatever. Suppose what the submissions we submitted during the adjudicating proceedings, that becomes very important document, because whatever has been agitated before the adjudicating authority is goes along with the whole battle of the litigation. And then the power of attorney, the person who is filing the appeal or who is appearing on behalf, because filing is generally done by way of login in the portal, and when you log in, there must be some authority to log in, or the supplier himself log in and file the appeal. So depending on the facts of the case, this power attorney also become very important. So these are the major documents in filing the first appeal. And after this, if you see what are the major considerations so far as the drafting of the facts of the case is concerned. I will take one by one. The first and foremost is about the supplier and business profile. In the facts, we tell about the constitution of the supplier, whether it is a company, firm, proprietorship, who all are the partners, and what is the uh, SIN number there, or what is the registration number, and about the business profile also. This is very important. Unless the business profile is there, the appellate authority or higher authority will not be able to appreciate the issues or concern raised by the appellant. So this part is a major consideration. Then chronology of the events happened. We need to have a chronological order that what happened, whether initially there was a ASMT 10 and later on there was a DRC 1A pre-show cause consultation, and after that the show cause came, and after that you submit your replies, and then came the order, and which against which you are filing the appeal. So this chronology, if you have in the facts of the case, that will help in arguing the matter, and that will help the appellate authority to understand the sequence. And very important issue regarding the drafting of the facts of the case is that it should not be mixed. Like in facts, we generally mix the grounds also. In facts, only we started saying that this order is illegal and this has been passed without considering the facts, without taking into record the submissions, and this is not as per the section so and so. Facts must be clean, and that should be that is very important, because if the matter goes till high court or supreme court, these facts become very important, and if these facts you are not able to stand, then your case becomes weak. So that should be kept in mind. Then we come to the reference to the you know ASMT 10 or SCN, we give the reference that when the show cause notice was issued or any other pre-show cause was issued. After that, reference to the submissions, whatever you have submitted, and that reference is required in the facts of the case. All details. If suppose this show cause notice has been culminated due to the audit proceedings, there was a departmental audit under section 65, then the reference to those audit proceedings, audit memos, number of days taken, number of mail exchange, documents submitted, is required to be mentioned in the facts of the case, so that it becomes part of the record. And then a reference to finding by adjudicating officer in order. You need to summarize the findings of the adjudicating officer also. Generally, in order they also summarize the findings. But it is important that if you mention in facts that this is the findings of the adjudicating officer in summary form, and about the order, date and surveys and communication and all that, because it may involve the continuation of delay also. So that is very important. So these are the major considerations so far as the facts of the case are concerned. Now coming to grounds, that basically there are two types of grounds which we take. One is the legal grounds, we call technical grounds also, and another is the factual grounds, case on merits. Case on merits, factual ground depend on case to case. Like nowadays in GST, major sections so far as Section 73 is concerned. Because 73 cases are other than fraud. It means there is no mala fide intention. There is no, but it may be due to mistake or whatever, and the penalty is also lower side. Maximum 10% of the tax amount is a penalty under Section 73. So these factual grounds are relating to the mismatches, or I already told you regarding the reversal of ITC under Rule 42 or 43 and whatever. Now coming to technical grounds, the major technical ground is one of the ground relating to jurisdiction, and jurisdiction on many counts, that it was beyond the competence, beyond the jurisdiction of the proper officer or the adjudication officer to pass this order. And how it was beyond, maybe it was due to the limitation period, which is already challenged so far as the 31st March 23 notification is concerned, so far as the another notification for 1 month extension in 18, 19 and 1920, that is in the month of December, is concerned. Another ground could be the opportunity of being heard. If you did not get the opportunity of being heard, if you did not get the personal hearing notice, no opportunity, if you were not allowed to submit your submissions, if the order passed is not the speaking order, then these could be a legal ground. And if the order was passed without considering the submissions or reply, or when the virus or any provision or rule or any notification is challenged, that is not the within the competence of the issuing authority or the rule making authority or the government whatsoever, then these are called the legal grounds, and it should be very carefully drafted that what grounds we are going to take so far as this appeal is concerned, because it will go long along. It will go long along. So this is we need to take care. And going further, if you see the time limit for filing the appeal. To appeal by any person, meaning by the supplier, normal period is 3 months, as I already told you, and it can be further extended by 1 month on condonation of delay, and there has to be some separate application for condonation of delay. If the appeal is being filed after a period of 3 months, but within 4 months, without any application for condonation, so that may be rejected, because you have not asked for the condonation and you have not filed the appeal. Period is not your right. This is only when the appellate authority is allowing you. And in the similar manner, the appeal by the Commissioner Appeal Department is normally 6 months, and there is a condonation provision, and that condonation provision is for 1 month. On limitation period, there are many judgments of Honorable High Court, and these has to be strictly adhere to, and there should not be loose. Now, if the order has been passed in December 2023 relating to 1718, the 3 months period is approaching near, that is March is coming, maybe depending on the date of the order, you need to decide the limitation period. In one of the case of Jindal Pipes Limited, Honorable Allahabad High Court has held that the service of order to the driver of the vehicle will not be treated as to the person who is aggrieved and who is filing the appeal. So if the 3 months period is to be applied, that will not be the service to the driver, but it will be from the communication to the aggrieved person, who is the registered person, who is the owner of the goods, who is filing the appeal in that particular case. Then we have a Meritas Hotel case also, Honorable Bombay High Court, and it has clearly rejected that if petitioner failed to file the appeal within the uh, period allowed under Section 107, and they find no merits in the writ petition, and writ petition was dismissed. In the similar manner, In case of modern steel, this is also Allahabad High Court. This is said that having been prescribed, when the period is having been prescribed in the statute had expired, the appellate authority rightly proceeded to dismiss the appeal. To various high courts, even in Kerala High Court also. And Kerala High Court also, there is no illegality in the action of the first respondent in rejecting the appeal as time barred. So they also, the Bombay High Court, the Allahabad High Court, the Kerala High Court, many high courts are on this issue have clearly said. And relating to the service of notice, only I would like to say something that clause C and D. Clause C says that sending a communication to email address provided at the time of registration or as amended from time to time. Now, it is very important to amend your contact information. If email has not been amended and your email is wrong email at that point of time, which you are not using or not working, then it will be very difficult because as per section 169, it will be treated as service. It will be treated as service of the notice. But if you see 107, the communication and service are two different terms. We need to analyze those also. And it is very important that we file our appeal within